Operations and Intergovernmental Relations Committee meeting for Tuesday, February 16, 2016 will please come to order, and the clerk will call the roll.
Calling the roll, Mr. Miller.
Here.
Ms. Simon. Here. Mr. Brady.
Here.
Mr. Germana. Mr. Germana is absent. Mr. Greenspan.
Here.
We have a quorum.
And is there any public comment related to the agenda?
No, Mr. Chair, no one has signed in.
Okay. Approval of the minutes from the January 29, 2016 meeting. Those minutes are in your packet. Do we have a motion? Is there a second?
Second.
It's been moved and seconded to approve the minutes from January 29th. Any further discussion? Hearing none, all those in favor say aye. Aye. Any opposed say no. Ayes have it. Minutes are approved from January 29th.
Just one abstention. I was absent.
Okay, one abstention is recorded. Okay, item number 5, matters referred to the committee. One piece of legislation, ordinance 2016-0002. Yes, Christine.
Ordinance 2016-0002, amending titles 4 and 5 of the Cuyahoga County Code to clarify the ethical rights, responsibilities, and prohibitions applicable to elected officials, employees, board members, contractors, and lobbyists of Cuyahoga County.
Thank you very much. This is the first hearing on this piece of legislation. I don't expect that we'll take action to pass it out today. What I expect is that we will have the sponsor make an initial presentation so that we can hear what's included and get questions out on the table. And then Linda Mayer from the League had signed in for public comment, but I suggested that we could hear her present as a witness on the legislation so that we can have some interaction if we want to, and then we'll have general questions by any member of the committee and see where we are. So with that, I will turn it over to the sponsor, Councilman Greenspan.
Great. Thank you, Mr. Chair. Mr. King, if you can approach the podium. So look, this obviously, as we know, since we first introduced the ethics ordinance back in January of 2011, and we adopted in April 2011, we've been very thoughtful on an annual basis, although we haven't done it in the last 2 years, gone back and taken a look at the legislation to see if there are any unintended consequences, which we did make some shorter term amendments as discrepancies in practice or other matters came to our attention. So this is merely another review of the ethics ordinance as we did in 12 and 13. We just didn't do it in 14 and 15 in a wholesale perspective. What this does structurally, and it may look different, and that's why it's hard for us to give a straight red line copy of this ordinance compared to what was previously in place, is two fundamental changes. Number one, we removed the verbatim incorporation of the ORC provisions. That was removed because of the changes in Ohio ethics laws, and that if we didn't make the change in our ordinance when an ORC provision changed, our ordinance was then in conflict with the ORC. What we do is reference the applicable sections in the ORC that relate to ethics codes. The other thing that was fundamentally done in this presentation is it's segregated by applicable users. So employees, elected officials are in one section, lobbyists are in another section, and contractors are in another. That way, if you're in one of those special groups, you really focus on the areas that pertain to you. Those are kind of the main, I would say, two overarching changes. Number one, once again, to reiterate, no verbatim reference to the ORC, but a direct reference to the applicable sections. And number two has to do with the realignment of the presentation to be based on users as opposed to an overarching policy itself. There are some, and I point to the summary that Mr. King put together, as I asked as we went through this, that he provide a summary document, which he has done, and that's the document that we have in front of us, which explains the changes. Just to give you a perspective on this process actually started when Sister Joanne Gross was here, and so it's been somewhat in various forms for the last 3 years. Since we've come up with this format, and a couple of the changes which we'll talk about, proposed changes that are in here, this has been reviewed not only between the former law director and the current law director, our former and current counsel lawyer. The executive is reviewing it. He and I have met with Mr. King twice to go over some concerns. We're going to meet a third time. And also the Ohio Ethics Commission, not in an official capacity, but has had an opportunity through its director to provide us input into some of the changes, and he's provided some insight. And obviously, the League of Women Voters, when we released this, we did forward a copy to them because of their obvious interest in this as being one of the original working groups during the transition process going back to 2010. So what I'll do right now, and Mr. King and I will probably play off each other, but I'll turn it over to him to kind of walk through some of the major, I'm reluctant to even use the word major, some of the proposals that are in here, because they're not de minimis, but they're not major either, if I could put it in those terms. So, Mr. King.
Certainly. So just running through the summary very quickly, I'll touch upon some highlights here. Just in terms of the definitions, there were two sort of major changes here. One was we tried to reduce the number of definitions, because in the current ethics ordinance there are, I think, close to a couple dozen definitions. A lot of those terms didn't need to be defined in the level of detail that they were, so we tried to simplify it for the reader. Substantively, the biggest change is currently the ethics ordinance talks about public officials and employees, and that actually mirrors what's in the revised code. But for the purposes of our ethics ordinance, and this was born out of some practical considerations, we decided to separately define public officials, elected officials, employees, and board members. And the reason for that is because we have a number of board members serving throughout the county on appointed by the county executive or council. A lot of them are in an uncompensated capacity, and there are legitimate differences between the responsibilities and the obligations of board members and county employees. So it was really an effort to make a distinction between those types of roles. And many of the requirements of the new ethics code apply to both, but there are some deviations as we go through where board members may not have the same types of restrictions that employees have, simply due to the more ancillary nature or relationship to county government. Moving on to training, the new code explicitly allows acceptance and acknowledgement of completion of training electronically. Currently, there's acknowledgement and acceptance is required, but we wanted to make sure that, given the way it's been operationalized, which is through a video produced usually by HR or the Inspector General, that we could have people acknowledge completion of the training online. It was really a practical consideration. It saves a lot of paperwork in terms of having people sign documents just to be added to a personnel file. So it's something that can be achieved through MyHR. It also distinguishes who does the training. So for lobbyists and contractors, we have the Inspector General do the training, as that's more of, they will be under more of the purview of the Inspector General from a regulatory standpoint. For elected officials, employees, and board members, typically we expect the Department of Human Resources to conduct the training. The next section, and feel free to jump in if any of you have any questions as we go along. Use and misuse of county resources. The first major change here right now in our ethics ordinance is the regulations governing the use of procurement cards. That is more appropriately and actually is also regulated in the county's procurement policies that have been approved by this council in the past and are implemented by the Office of Procurement and Diversity. So we took out explicit references to the procurement cards, but obviously use of procurement cards would still be subject to the same restrictions as use of any other county resources. So from one of the things that, sort of taking a step back, we fundamentally tried to do with this is, let's segregate out what is really an ethical consideration versus what is a practical operational consideration or a human resources consideration. So this is one of those areas where use of county resources, misuse of county resources is clearly an ethical consideration, but it wasn't necessary to delve into the specific policies of a procurement card in this policy. That can be governed by our procurement policies. There was a de minimis exception added for the use of county resources for personal purposes. One of the issues that arose that was never really enforced, but a lot of people had concerns about, was using a county computer to check a personal email. Now, that's certainly a management concern if there's waste or abuse or whatever on county time, but unless it was for political purposes or to conduct your personal business outside of on county time, that it didn't, using your county computer to check a personal email, for instance, wouldn't rise to the level of an ethical consideration. Obviously, use of county networks, systems, and printers all employees are still subject to the IT use policies that every employee has to sign. Again, segregating out what is really an ethical consideration versus a managerial one.
Now this only pertains to de minimis
Correct.
use. This isn't somebody comes in and, prints 500 copies of a document on the county copier as an example. It's a de minimis definition is inserted.
Correct. The next section relates to the use and misuse of one's official position. This is substantively more or less unchanged from the current ethics ordinance. It's similar. It's not verbatim the same in every respect. It does mirror a lot of the Ohio Revised Code requirements related to the letting of public contracts. One of the changes is that the ordering of goods or services for county use without prior official authorization is no longer a per se ethical violation, because currently in our code it says that if you authorize the ordering of goods without authorization, that is again an ethical violation, but again remains an internal control matter enforced at a managerial level. Unauthorized ordering of goods or services for personal or non-county purposes continues to be an ethical violation under this code. So that just one distinction there. Moving on to conflicts of interest. The requirements here are again reworded, but are substantively the same. Matters involving the exercise of discretion coming before an elected official, employee, or board member that could result in a financial or material benefit to that individual. That individual has a duty to recuse themselves from discussing or voting on that matter. There are some additional restrictions, and these are more technical, about individuals obtaining a financial interest in exchange for services rendered by the county. Again, this is intended to mirror Ohio Revised Code section, just to make sure that everything is in line there. One thing it clarifies, currently in the code it says that if an employee or elected official is uncertain as to whether a conflict of interest exists, they are to ask the Inspector General for an opinion as to whether a conflict actually exists. One of the things that came up was there may be instances where someone may have a legitimate concern about conflict of interest, but may want to have their counsel look at, make that determination rather than the Inspector General. There's no attorney-client privilege between an elected official or employee and the Inspector General. So this basically gives them the option to either ask for an opinion from the Inspector General if they're looking for more public cover, to say, I asked the Inspector General to review this, it's been deemed okay or not. But if you want a more confidential or more, say you have a personal private interest that you don't necessarily want to advertise to the world, you can go to your attorney and say, I think I might have a conflict here, and get an opinion there. It doesn't provide the same type of legal cover potentially that an Inspector General opinion could, but it's an alternative avenue. Another option that always exists is you can request an opinion from the Ohio Ethics Commission, and actually if you get one of those, that actually gives you legal immunity under state ethics law for participating in a matter, assuming the opinion comes back saying that no conflict exists. So that's generally the conflict of interest changes. Nepotism, this section is substantially the same. I'm not going to touch on it very much. It's a slight tweak to the prohibition on family members working in the same office. One thing was currently, if you're working in the same office, potentially one employee would need to be transferred. This is limited really to only either making a hiring or employment decision or having a direct supervisee. A relationship is prohibited, but having two employees work as colleagues isn't, again, an ethical violation as long as there's no direct fiduciary, interest that, or familial interest that one would be making decisions about the other. Gifts, this is one where there were some changes made. Current state policy is that gifts of value that have an actual or substantial or improper influence on an individual are prohibited. And that standard is incorporated in this code and applies to county officials and employees as it always has. In the current ethics ordinance, we created what I call a hard cap, saying that if a county official or employee accepted a gift over $75, then as an annual aggregate from a contractor or lobbyist, that would be a per se violation of the ethics code. That seemed a little extreme in certain respects. If there were ceremonial or familial relationships between a contractor and an employee who may not have any relationship to the wording of a contract or this or that, that restriction was a little overburdensome. So one thing that we tried to do here was create a little bit of flexibility, and where we landed was essentially creating what we're calling a presumption of influence, so that if a county official or employee receives a gift in excess of $75 or cumulative gifts annually, then that official or employee will be presumed to have violated the ethics code, but that they can rebut that presumption. So if the inspector general comes knocking on their door and says, you accepted a $75 gift card for Christmas from this person who's a county employee, or county contractor, that employee or official can say, wait, it was a Christmas gift. Contextually, it adds an element of reasonableness to it, and it no longer has that strict liability component, which was raising concern in certain respects. But it still keeps the $75 cap as a guidepost for the inspector general and employees and elected officials to say, this is where we're drawing the line. And it doesn't mean that if you cross the line, you're going to be off scot-free. It's on you to prove that the gift was reasonable.
So the $75 is still present, but the added language of there being a presumption of influence has been added. Mr. Miller.
Mr. Chairman? You're waiting for an answer.
No. I was making a statement. I was saying that.
Okay. Mr. Chairman, Mr. King.
Yes.
I think I mean, help me out here.
Sure.
Because I heard what you said you were trying to do, but when I read it, it sounds different to me when I look at the language. It sounds like you have to prove you're innocent, and I'm not quite sure how you go about that, or that seems, not being a lawyer, that seems contrary to what I would expect.
So just a little law school 101 here. When we're talking about intent, right? Normally, one of the things in criminal law, when you think about intent, is different crimes have different levels of intent. So for murder, you have to have either purpose or knowledge that you're going to kill somebody when you do an act. That's the highest level of intent that you can prove. Then there's recklessness, which requires you to basically be negligent in your actions. Then we have what's called strict liability, and that's really the lowest level of intent that you have to apply, and that's more like if you're jaywalking. You don't have to intend to jaywalk. If you jaywalk, you can be written up a ticket. No police officer has to go into court and prove that you had purposeful or knowledge to jaywalk, right? So typically, specific intent or strict liability crimes are lower level crimes in the criminal justice system. As currently written, the ethics ordinance creates this gift receipt as a strict liability violation. So if you receive $75 in gifts, you don't even have to know that the person you're receiving it from is a county contractor or lobbyist. You violated the ethics ordinance. Now, I think most people would say that's a little unreasonable. So I understand how it reads perception-wise. It seems like it's on you to prove your innocence, but really what it's doing is adding in some flexibility to say, you're not automatically in violation of the ethics ordinance. You now have an opportunity to say, there's some reasonableness in here, or that I didn't know it was a county contractor, or that it was part of a holiday or a birthday or a wedding or something, and it was a reasonable, ordinary character type of gift for that type of event. So that's really how we approach this.
Okay, you're the lawyer.
All right.
On that point, am I correct that the ethics code itself does not create criminal liability,
That's correct.
but the ethics code in the Ohio Revised Code does?
In certain respects, yes. Not all. Chapter 102.03, I don't believe carries criminal penalties, though it does. I believe it can. Sections in 2921, that is actually in the Ohio Criminal Code relating to soliciting or accepting improper compensation or having an unlawful interest in a public contract. Those are criminal penalties.
And am I right in the state code if is the $75 number, is that in the state code as well?
I believe the $75 number, it's not in the state code, but I believe it was part of guidance that was put out by the Ohio Ethics Commission at some point under Chapter 102.03E, which is where they interpret the substantial and improper influence.
So if they find improper influence, that's a criminal violation, is that correct?
I don't know that off the top of my head, but I can get back to you on that.
But on that, they would have to, the burden on them would have to be to prove the intent, is that the influence?
Correct.
So they would have to prove that there's influence in order to violate that state code section.
Correct.
Now, on the presumption of influence here, if there's a presumption of influence against you, the initial question is, well, who do I have to go to rebut the presumption? And I presume that the Inspector General is the arbiter of that. Is that correct?
As currently written, yes, that's correct.
And where is that stated?
I don't know if it's explicitly stated. One of the sections later on does spell out the rights and responsibilities of the different parties. It may be stated indirectly in some respect in Chapter 407, which outlines the Inspector General's responsibilities as Chief Ethics Officer in determining when a violation exists. I don't know that it specifically talks about determining the reasonableness of rebutting a presumption of influence. But that can certainly be added if that's something that...
We should think about
Okay.
an explicit statement. Please continue.
All right. So the next section relates to financial disclosure. This section is substantially similar to what's in the current ethics code, but more narrowly defines the list of employees who must file financial disclosure statements with the IG. Obviously, all elected officials and directors are required to file. There was language in the existing ethics code that talked about anybody who reports to a director, and there's some ambiguity in that. So basically, we just tried to more specifically define who's required to file a financial statement, just so everybody knows, whether they hold a position that has that requirement or not. Next section, secondary employment. Employees and elected officials, again, are still required to report secondary employment or private business activity to the Inspector General. However, the requirement is limited to income reportable to the IRS and excludes various types of unrelated gross income. So for instance, if you get money as part of an inheritance or something like that, you don't have to report that as private business activity. That's clearly, it's income, but it's not something that you've done either as an employee of another entity or done as an independent contractor as a private business activity. So that's listed in that section. It also, the current code requires employees to resign when the Inspector General determines a conflict of interest. The new code follows the established recusal procedures. So if you have a conflict of interest with a secondary job, then you will have to recuse yourself unless the conflict would preclude an employee from performing a substantial portion of his or her job at the county, in which case you may have to resign or quit your secondary employment. And then finally, the new code requires employees to request approval from the Inspector General within 30 days of accepting secondary employment. Currently, as it's written, you have to request an opinion prior to accepting secondary employment. That was burdensome both on the employee and on the Inspector General, and this was actually something that the current Inspector General had requested, this 30-day window be put in there to provide, to pull pressure off of both the employee and the Inspector General if there was a job offer pending or something was time limited in some fashion. So, and then the Inspector General has 14 days from receiving the request to render an opinion. As for future employment, the new code mirrors the one-year prohibition currently in existence in Ohio Revised Code 102.03 on any outside representation on any matter involving the exercise of discretion in which an individual has personally participated. And I believe that's basically the same as the existing requirement. There's a section relating to discrimination. The existing code of ethics applies to public officials, operations, or entities of Cuyahoga County government. The new standard would apply across the board, including to county contractors and lobbyists as well. And the new code intentionally omits reference to the sexual harassment policy that's stated in our current ethics ordinance. And the rationale for this is, again, we're segregating out what's really an HR function and what's an ethics function. Sexual harassment, while of course reprehensible, doesn't necessarily implicate the same ethical considerations that would normally apply. And so this was something that should be and is in our HR personnel policies and procedures manual, and is also explicitly prohibited by county law in the charter and as well as in the code. Political contributions. This was one area that I think came up as part of the discussion about 2 years ago, I think, related to the appointment of nominees and whether or not political contributions could be, limitations could be imposed on appointees who are not employees of the county. Ultimately, the new code prohibition applies only to campaign contributions between elected officials and employees. It does not include, as the current code is written, board member appointments, particularly uncompensated board member appointments, because there are constitutional considerations. There are First Amendment implications about political contributions, and given the number of boards to which the county appoints and the uncompensated and in many instances volunteer nature, that a complete prohibition on the making of political contributions would constitute potentially a First Amendment violation. So the new code is restricted principally to employees. It restricts both employees from making or soliciting on behalf of an elected official, and also prohibits elected officials from soliciting anybody that they might appoint or confirm. So the other distinction here is that the political contribution prohibition has been expanded to include employees whose confirmations before council is pending. So for instance, a director, departmental director, if they were appointed by the county executive, during the time that confirmation is pending, that director would be prohibited from making a political contribution to either the county executive or the council. So but again, since it's limited to employees of the county, it really principally applies to directors and not board members. And then finally, the new code explicitly incorporates the revised code's provision of classified civil service employees from engaging in partisan political activity. That's something in civil service law that we just wanted to capture in here.
I have a couple questions on this section.
Sure.
First of all, when you said that it does not apply to board members, especially when uncompensated. Well, if you have a board member that's compensated, does it apply to them or not?
As currently written, it does not. I'm 99% positive of that. One of the things as we were discussing this was I do believe it is more legally defensible, though I'm not guaranteeing that a regulation that would apply a prohibition on political contributions to compensated board members. And remember that most of these board members will be compensated by an outside entity. RTA is a compensated board. RTA compensates their members. The county does not. That you could, and again, diverting into legalese here for a second, the Supreme Court applies strict scrutiny to limitations on free speech. And for better or worse, the Supreme Court has opined that these types of political contributions are a form of speech, and therefore require that when governmental entities regulate political contributions in this way, that they have to apply a narrowly tailored remedy. And there's actually a challenge right now to an even more restrictive, and I haven't checked on this in a little while, so it may actually be resolved, but a more narrowly drawn up prohibition at a federal level on contractors making political contributions to elected officials at the federal level. There has to be, you have to have a direct connection there. And given the history, I understand, given the history of the county, that there is a reluctance and obviously a concern there. There's been a past that could justify some type of political regulation of political contributions, but imposing a flat prohibition in the same way that the county can't simply jump to race-conscious corrective programs without a disparity study, I don't believe would withstand constitutional scrutiny.
As currently written, and also as proposed, it appears to suggest that that if the county executive is running for re-election, that county employees would not be allowed to contribute to that county executive's campaign, but could contribute to that executive's opponent's campaign. My question is am I correct in that? And if so, would it be legally permissible for us to say that that a county employee may not make a contribution for any candidate for office of which their employer occupies, and that any candidate for such office may not solicit county employees, so that it's balanced? Can we do that?
To answer your first question, yes, you are correct in that. To answer your second question, that I think is a conversation that this council should definitely consider. One of the things that I've struggled with in trying to help redraft this is there's a whole set of campaign finance regulations at the state level that do apply to local elections. So candidates for county executive right now are subject to state law and what they can solicit or accept from county employees. And I don't remember that off the top of my head. It's been a little while since I've reviewed it, but I would urge, that if this is something we as a county wanted to explore, that council consider, rather than doing it through our code of ethics, that it actually establish a set of campaign finance regulations, campaign laws. And that should be part of, I think, a larger scheme of how we consider county elections.
I think there are reasons why we have not adopted any such legislation so far, and that a one-liner within the ethics code might be more practical.
And that's certainly reasonable. One of the things that I know was a consideration when we were talking about restricting political contributions to outside, to a candidate who might be running for county executive who's not yet in office is, as currently written, this ethics ordinance and our current ethics ordinance applies to public officials and employees. So if you're a candidate for a public office, you have not yet fallen under that umbrella. So I think it would be a little more involved than simply making a one-liner to talk about it, but it's something that we can certainly discuss if that's something you'd want to pursue.
Understood. It's worthy of discussion, to
Mr.
quote the
Chair,
council president.
I'm unclear of what you're suggesting, that perhaps an employee would be prohibited from contributing toward somebody's campaign who currently does not hold office?
Well, what I'm suggesting, and I'm not saying that I've come to a conclusion about this, but I'm raising the point that as it's currently written, if the county executive is running for re-election, a county employee cannot contribute to that county executive's campaign, but the county employee may contribute to the person who's running against that county
Yeah,
executive.
and Mr. Chair, in due deference, I'm surprised what Mike King said about that. That would be extremely prohibited by the Supreme Court for prohibition of freedom of speech. I can't believe you even suggested that that might be a possibility to start controlling employees' ability to contribute toward political campaigns. That to me would be strict scrutiny and certainly not be upheld. That's a clear line for, I thought. So I'm pretty surprised by your response that you would say that would be something to consider or happen. That's completely out of line, out of what's considered allowable under the Supreme Court line of cases.
So the Supreme Court, I did have a chance to look into this too a little bit. The Supreme Court has upheld the Civil Service Code restrictions on employees from engaging in partisan political activity, and that would include raising money for campaigning for elected officials in a partisan office. It has also upheld existing campaign finance laws saying that employees may not make political contributions to an individual who they are in the direct line of reporting for. So for instance, if you work in the governor's office, your employees cannot give you a campaign contribution, nor can they give a campaign contribution to anybody running for the office in which they work or for which they work.
I'm just telling you right now that that's going far beyond what we should be doing in this chamber. This is outrageous. And why don't we start looking at people who contribute toward judicial campaigns, that if they have a case in that courtroom, perhaps they're going to give money to the candidates and not be able to do that because one day this other person running for judge might be overseeing their case, and that could be considered influence. I think we're really going beyond what we should be doing sitting in this room and putting the kibosh on employees beyond what civil service is obvious. That's in the state code. We all agreed that made sense, but I'm going to say right now that we're really getting involved with things we shouldn't be. That's my opinion.
Okay, I appreciate the feedback, and again, I didn't come with a predisposed opinion. I just wanted to raise the question, and I have one more question to raise, and in this case, I think the language that we have is too restrictive, and it relates to Section C of proposed 403.11, which reads that the prohibitions in this section shall not apply to employees or elected officials whose service with the county has terminated more than 12 months prior, which seems to imply that when you leave county employment that you're still under restriction for 12 months. And for example, if a person were a county executive and decided to resign from county executive because he or she wanted to run for another office, that person would have to wait a year before they could solicit any county employees for a contribution, and my question is whether that's good policy, given that there would seem to be no longer any conflict of interest.
Well, I'd defer to the council as a whole on what's good policy in this instance, but I will say that in the current ordinance, there is no time limit as to when the prohibition applies. It simply says that if you've been appointed by a county official, that you cannot make political contributions to that elected official, period. It doesn't say that prohibition ends when you leave office. It doesn't really speak to that. So one of the reason this section was added was to add a sunset or an end date as to when that was. 12 months after leaving office seemed to be a reasonably prudent time period, but if council would like to amend it to a different time period or until the termination of employment, then that's certainly within its prerogative.
Okay, that's
Thank you.
out
Yes,
under consideration.
Thank you.
Okay, Council President.
A statement as a veteran local politician in Cuyahoga County. I think it's good to keep things in perspective here. It wasn't that long ago that Sheriff McFall was having his clam bakes, and there were 1,000 people there, and the tickets were sold by employees and friends of the county sheriff, and everybody in the county who was not everybody, almost everybody in the county who was involved in politics would be there to campaign because it was one of the largest events in the county. That the county treasurer's office, I'm not talking about anybody as an individual, I'm going back now long before anybody you've ever heard of. People in the county treasurer's office almost, not completely, but almost exclusively financed the county treasurer's campaigns. People in many of the other offices almost exclusively financed, not completely, but almost exclusively financed, made a big portion of that money up that was raised routinely by county officials, and not just here, of course, across the United States. So the fact that we're where we are and that we're even talking in these terms, I just want to remind us how very, very far we've come, that we're needing to thread the needle so much in order to try to make some progress, which I'm not against, but I think it would be inappropriate to give to have any impression that that's what is acceptable anymore, or that we're trying to prevent something from happening that's occurring or you expect to occur. I know we're going over the ethics ordinance, we're reviewing it, and I think that's fine, listening to the conversation. But just as someone who's been around a while, things have changed for the better, and it hasn't been that long ago that all of this happened. So keep it in mind.
All right.
Continue.
All right. The next section is very quick. It's the county's whistleblower policies. It's very similar to the existing whistleblower policies. It's mirrored after state law. One thing that is clarified in here is that the Personnel Review Commission has the appellate authority to hear claims of retaliation. So if somebody files a whistleblower complaint, they're retaliated against in an employment setting, then the Personnel Review Commission will hear appeals of those retaliations. There's actually one caveat to this that I think in conversation with the county executive and the law department, there may be instances where retaliation claims need to be heard by the State Personnel Board of Review, despite what's in here. And this has all been in communication with the Personnel Review Commission. It is likely this section will be updated. I just wanted to give you a heads up on that as we move forward. Next is contractor and lobbyist registration. This is, again, substantially similar to what's in the current ethics ordinance. Again, the prohibition on gifts applies similarly to contractors and lobbyists, as well as the employees and public officials. And then one change is that the new code adds a registration threshold for contractors. Currently, how it works is if you are, I believe, if you're over 10, if you do business with the county for less than $10,000 a year, you're not required to go through an ethics training, and you're not required to pay the registration fee, but you are still required to register. There were instances in the past where we would have contractors that we were either mandated under federal law to contract with, or instances where you would have small purchases, through a procurement card. Maybe somebody would, go on a staff retreat and order lunch, something like that. Something that is permitted under our purchasing policies, but maybe you can't get Quiznos or whoever it is to fill out a contractor registration form. So one thing, and this was actually at the recommendation of the Inspector General, was to say let's set a definitive threshold, and we set it here at $10,000, so that if you do more than $10,000 worth of business annually with the county, you are subject to all of the requirements of our ethics code. That includes registration, paying the filing fee, the registration fee, as well as doing the training. And contractors are responsible for keeping track of how much business they do with the county, and if they exceed the $10,000 threshold and don't register within a timely manner, then they're potentially in violation of our ethics code and could be subject to debarment. So that is one substantive change there. The registration and training requirements for lobbyists no longer applies to bona fide members of the media, governmental entities, and other agents. One thing I neglected to mention earlier in the definitional section is we are updating the definition of lobbyists to be a little more precise, and I think that definition is going to be even further refined, just based off of the conversations that Councilman Greenspan and I have had with the county executive, as well as the conversations I've had with Councilman Miller. And then finally, what this code does is it specifically delineates the responsibilities of the different enforcement authorities. And those authorities here are the Inspector General, the Human Resources Department, the Department of Law, as well as the PRC, which their role, again, is limited to the hearing of whistleblower appeals. There are some minor changes here. Basically, when the Inspector General or Law Director are conflicted out of rendering an opinion, they can appoint individuals to sort of step in an ad hoc basis to perform powers or duties of that official. Say the Inspector General has a fiduciary interest in some matter that is under investigation. There, it just creates some flexibility there. And one new thing it applies to the Inspector General is that the Inspector General has to take reasonable measures to protect the anonymity of complainants and witnesses. And I know this was an issue in the past where somebody had been under investigation. The Inspector General had published her findings on the website, and it had names completely exonerating the individuals, but still rose to the level of having your name published in a report that potentially included something that could be considered disreputable. So again, reasonable measures. It doesn't mean that it guarantees anonymity or confidentiality of any witness or complainant, but reasonable measures to protect that type of anonymity. Let me just see. It updates the ethics code to include the Inspector General's ability to debar. That was the debarment ordinance was passed after the original ethics ordinance. This just brings that enforcement authority more explicitly within the ethics ordinance. It tasks the law department with creating and updating a comprehensive ethics manual for ethics training. And this was something I know the original ordinance was intended to be a comprehensive manual in and of itself. But again, with the issues related to the revised code being changed, and we would have to update, and there's potential conflicts that would arise. This was the compromise position to say, okay, we'll have our law department, who should be keeping track of the ethical rights and responsibilities of elected officials and employees, put together the manual, make sure people know what they're ethically required to do, and update it when either local or state ethics law changes. And then one final amendment related to the notice of debarment. This was something that the Inspector General had requested simply to doing with notice. It is a procedural technical issue. I'm happy to discuss it further if anybody has any questions, but it's more of a footnote.
On the enforcement authority, where it says the IG needs to take reasonable measures to protect the anonymity of complainants and witnesses, is the IG also required to make reasonable efforts to protect the identity of the person that the complaint was against if the person is exonerated?
That is not explicitly in the ethics code. Potentially you could, again, I'm coming at this from an interpretation standpoint, but you could consider somebody who is under an ethics investigation to be considered a witness until an ethical violation has been found. So in the definition of witness, again, we don't define witness in the ethics code, but that could fall under it. But at the end of the day, it's going to be difficult for, if someone is under direct investigation, any report that the Inspector General produces is eventually, it may during the investigation be, part of withheld from public records disclosure. But at the end of the day, once that investigation is complete, any reports published are going to be public record. And so it's very difficult to issue a report about somebody who's under investigation without citing them by name. So that, but that's certainly something, I mean, if this council would like to include or request the feedback from the Inspector General, that's certainly a conversation that can be had as well.
Any questions? Any questions that anyone would like to ask before we hear from Linda Mayer?
Motion to adopt? Just kidding.
Okay, well, we're going to call forward Ms. Mayer from the League to present comments on behalf of the League.
Hi, Linda Mayer here. I've got a written copy of roughly what I'm gonna say. So I can then just kind of ad lib to it. So
That'd
I'll
be
give
great.
everybody one of these.
Absolutely.
Yeah, Linda, if you'll just give me the clerk, she can pass it out to her.
Thanks very much for sending this ordinance, the whole text, as well as the summaries. And I'm going to go through in the order that they're in the summaries. And I'm going to say just a few overview things about the impression of the entire effort. And then I'm going to also take a few specifics from these categories in the middle and then ask a bunch of questions. This is just a preliminary talking between some of the members of the former Ethics Committee from 2011. And actually from 2010, when roughly the same people were acting as the transition work group, proposing a code which we thought were pulled from the best of the codes we were able to discover around the country. So we're really very interested in this effort to clean up what was done in 2011, but we're a little worried about it. So the first thing I want to say is, in general, we still wonder why a full rewrite of this thing is necessary. It's not really bad that legislation looks like legislation. You could do many of the same things just by creating a user-friendly training manual for employees and other covered persons. And you could accomplish some of these things without rewriting the law. You could also piecemeal update the spots where troubleshooting over the 4 years of use have shown that something is needed. So keep in mind that we need to be convinced that this is necessary. We liked the fact that the original code had been really carefully vetted, and I was comforted to hear that some vetting has taken place on this new version as well. So just keep that one in mind. The next one is actually only an issue we have with the summary and not with the law itself. And that is that it keeps calling it the new code. And the word new, are bothered by the word new. And to me, it seems it sends the wrong message out. If I'm the public and I hear that there's a new code of ethics, I think, whoa, this was one of the big reforms that happened in 2011 in the first year of our new government. And was it really just a temporary thing? And now we have a new executive, a somewhat new council, and we're rewriting it from scratch. And maybe that's going to happen periodically, and maybe if we don't see every little teeny change that's in it, maybe it's weakening. So that's one thought. We'd prefer if you used a word like revised or restated or reconstituted or something. That's a matter only of appearances. The next one we really like about this is that it does spell out the enforcement mechanisms. The enforcement mechanisms we felt from the scratch ought to be in the code itself instead of scattered around amongst different ordinances. So this we think is a very good thing, to put the teeth in there where the training, where the people being trained and the public and the press can see that this ordinance does have teeth. Point number 4, we know that discrimination and sexual harassment are violations of federal law, state law, employee personnel rules, but we don't see why you would put this phrase in the purpose of the ordinance and then take it out of the text of the ordinance and say, well, it's just these offenses are just personnel violations. So this is also a matter of perception, I think. Question number 5, we think your definitions have been inconsistent. We're wondering about unclassified employees, such as department chairs, staff members, who are perhaps not covered by classified employee rules, and yet they are also not elected officers. And so we're looking in the definition of employee, and it doesn't specifically name those people. So we're not sure that if I'm a political appointee in county government, whether I'm covered. So sometimes you just say officials, sometimes you say elected officials. And we think that these definitions ought to be consistent. And then the final thing that we, as an overall idea, is that we think that probably some corresponding changes will have to be made in some other policies and some other ordinances as well, particularly the Inspector General's ordinance. And so we're hoping that that's the next up on your agenda. Okay, point by point things. Let's see if I can shorten this part. In the training, we'd rather not that proxies can sign off for their person that was supposed to be trained. And I think when it's electronic, you're able to get somebody to sign for you. So that's just possibly a detail. Under conflicts of interest, there was a focus on direct financial or material benefit. That's a quote. What about indirect? What about benefits that are not financial or not material? we're not sure that those should be overlooked. Under nepotism, we like an expanded definition of what family is. And my own personal note is I really wish somehow we could put business associates in there too. But it's not technically nepotism. But the kinds of relationships that shouldn't exist between relatives also shouldn't exist between other kinds of connections. Okay, secondary employment. There's one word in there which bothers us quite a bit, and that's the word substantial portion. If the neglect of your county job is really not quite substantial, doesn't rise to the level of substantial, is it okay? I would think you wouldn't want any part of the county job to be neglected. So I think the word substantial is bothersome in here, and it would be great to replace it or take it out. Under contractor and lobbyist registration, we worry that contractors should not be in charge of keeping their own aggregate expenses to see if they reach $10,000, which will require them to be trained. We think that the procurement office probably has a record of those numbers, and it's better not to charge them with keeping their own. It's a temptation to downplay the amount of money that they've been receiving and receiving. Okay, county ethics manual. This is a great idea, and it wasn't mentioned by Mr. King in his summary, but we really like this. We also think it should be in something like plain speak, so that the people who are covered by this code can look things up after they've been trained and find what they're looking for. And so we even think a great policy manual like this could even be a substitute for rewriting the entire ordinance. We've got to go, and debarment, we think that's good to be in the code as well. We have a number of questions which you could possibly answer either today or at your leisure. But one question is that we've never been 100% certain that the independently elected county prosecutor is covered by a council ordinance. In the beginning, when this all was percolating, Mr. Mason was the prosecutor, and he was partnered with the reform group that pushed through issue 6. And he then thereafter said that his prosecutor's office would abide by the ethics code. It always felt a little bit optional to me. And I just wonder if that question has ever been settled to your satisfaction. There's a couple of places in here where the prosecutor's function is noted. And let's see if yes, this is in question number 1 at the last sentence. Are the private attorneys who are appointed by the prosecutor to work on specific cases, are they subject to contractor registration and other ethics provisions? I have a feeling maybe they are not. So it would be great if somebody could check that out. Second question, and this is actually 4 questions, and the reason they're all lumped together is because I don't think the answers to these 4 questions are explicitly stated anywhere, and I did hear in the previous discussion, one of these was brought up. Who's to know and judge whether a presumption of influence can be overridden or not? Who is to judge whether a substantial portion of an employee's job has been neglected due to secondary employment? Who judges whether outside earnings are unrelated to an employee's primary county position? And who will know whether a small contractor has reached the tipping point where he then must register and undergo ethics training? So, the recourse person isn't listed in these places. I guess it's the Inspector General, but maybe it's not. Maybe the Inspector General doesn't have authority in that direction or in that direction. So I think that could be spelled out. Number 3, if infractions by classified employees are supposed to be heard by, are supposed to be heard by the PRC, and that makes sense. What about the unclassified employees or the unelected officials and staffers? So we think the IG might be mostly an investigatory group, but the IG can also issue opinions. So maybe that needs specifying, not sure. Okay, number 4, failure to recuse, failure to file, failure to disclose. Are these violations? And are there any repercussions for those omissions? And who would detect that those things were omitted? I don't know. And then the final question is, we're wondering whether the chairpersons of key boards and commissions are also subject to disclosure requirements. I don't remember if they were in the original. We didn't do extensive comparisons, so we're not sure who was dropped from that list of required financial disclosure people. But so it would be good to see who's been dropped, to see whether any of those feel like they're sensitive. Okay, so those are some of our preliminary thoughts. And when you get up to second reading, we'll probably, if you get that far, we'll probably want to take a position, yes or no, voting yes or no on the whole package. But this is still formative now. So I would like to say that we're still not totally convinced that this is necessary. But you could convince us.
Well, it is obvious that you and your associates have spent a lot of time and have taken a pretty close look at this, and you're promising more, which we appreciate, and I think you've raised a lot of very good questions that need to be carefully looked at. So we're very appreciative of your interest and involvement, and I would ask my colleagues if there's any questions, and we're going to go to the council president.
Just comment and go ahead, but be moving on. I think that you've raised a lot of interesting questions.
I'm sorry, I can't hear very well. Can you?
Okay. I think you've raised some interesting points and questions, and I'm beginning to think that you might be right, that this might be unnecessary.
No, I'd really love to hear what Dave thinks about a couple of these, or about the overarching thing.
Sure, no, I appreciate that, and I appreciate the work you guys have put into it. The only thing I'm going to say is, because we just got this literally prior to you explaining the points, give staff and I an opportunity to review and counsel your questions, and then we'll get back to you. Because some of these I can answer and some of them we need to further
Because a
research.
couple of them I can take out right now. If there's an explanation, I just,
that's okay.
these were things that,
Sure,
that
let us,
particularly Janice and I were not able to find the answers to the questions we ourselves raised, so.
sure, and I think a lot of the points you raised are very good points. A lot of those we have had discussions during the compilation of this, so we'll go ahead and respond, as we review this to your specific questions. But I want to do it in a thoughtful and productive manner, instead of an ad hoc type of environment like we are now. Right.
I would also like to give assurance that there's nothing in this situation where there's urgency or any set timeline. I mean, we're going to be diligent. We're going to work through it. But there isn't any time by which we need to make a decision on this legislation or any amendments. We can take as much time as we need, and we're going to do that. It's obviously a very important subject that's central to the concept of the new government, and we want to do it right and present it right. You raise questions in both of those areas, and we're gonna take the time to do that.
Do you expect there to be any further sponsors of it? I guess that just happens by accumulation over the period of.
At any time during the process, any member of council may inform the clerk that they want to have their name added as a sponsor, and their name would be added. So it would be up to what any of my colleagues choose to do or not do.
Okay. Okay.
Okay. Thank you. Thank you very much for your testimony.
Sure.
Is there anything that anybody would like to say before we hold the legislation for pending further discussion? Hearing none, this will constitute the first hearing on proposed ordinance 2016-0002. And is there any miscellaneous business? Has anyone signed in for public comment unrelated?
No, Mr. Chair, no one has signed in.
Is there a motion to adjourn? I'll second. All those in favor say aye. Aye. Opposed? Thank you very much.